Hello everyone, welcome back. Today we're gonna study the third chapter from Business Laws and Ethics, that is Sale of Goods Act 1930. First, let's see what the act covers. The Sale of Goods Act 1930 regulates all contracts related to the sale and transfer of goods. This act does not apply to immovable property. It deals only with movable goods. So, now, for a contract to be called a contract of sale, three essential conditions must be satisfied. So, the first one is transfer of ownership of goods. That is, the main purpose of the contract must be to transfer ownership from the seller to the buyer. If there is no transfer of ownership, then it is not a sale. For example, a contract of bailment or hire purchase is not a sale because ownership does not pass. Second one is transfer must be for a price. The consideration for transfer of ownership must be money. This money is called price. If goods are exchanged for goods, it is barter system and that's not a sale. If goods are given free, then it is a gift and not a sale. The third essential condition is that it applies to business and commercial activities. That is, this act mainly applies to commercial transactions. It provides rules for trade between businessmen, traders, and customers. Now let's move on to the next topic, that is importance of this act. So this is very important for our economy because this provides legal framework, that is for buying and selling, defines rights, duties, and obligations. That is, this act clearly states what a buyer must do and what a seller must do. For example, the seller's duty is to deliver goods. The buyer's duty is to accept goods and pay the price. And this avoids confusion in trade. Helps regulate commercial transactions. Because since rules are fixed, business can be done smoothly. Both small shopkeepers and large companies follow the same act. This brings uniformity in the economy. Specifies remedies in case of breach. If any party breaks the contract, the act tells what remedies are available. Okay, now I will tell you the definition of contract of sale under section 4 of this act. And here we will be seeing the difference between sale and agreement to sell. So the first one is contract of sale. So according to section 4, a contract of sale of goods is a contract where the seller transfers or agree to transfer ownership of goods to the buyer. Notice two important words here, transfers and agrees to transfer. This means the act covers both completed sales and future sales. For a valid contract of sale, two conditions are compulsory. First, the transfer must be for a price. Price means consideration. If you give me your book and I give you my pen, there is an exchange or barter, and this is not a sale. If I give you a book free, it is a gift and not a sale. So sale must have money involved. Second, it can exist between any parties, any two parties actually, that is including co-owners. So this means one co-owner can sell his share to another co-owner. The next topic is sale versus agreement to sell. So a sale means ownership of goods transfers immediately from seller to buyer. For example, if you go to a shop, you buy a bottle of water and you pay 20 rupees and take it. So this is an example for sale. That is, there is prompt payment. So what about agreement to sell? In case of agreement to sell, the ownership transfer will happen only at the future time. So for example, I promise you to sell my laptop next month after you pay full amount. Till you pay and I deliver next month, I am still the owner. Today we only have an agreement to sell. Now let's move on to the next topic, that is when agreement to sell becomes sale. So this happens in two situations, that is when the specified time passes and the conditions required are fulfilled. So in these two cases, the agreement to sell becomes sale. So agreement to sell is only a promise. Remember, the key difference is time to immediate transfer means the condition sale, is future transfer means agreement to sell. Now let's move on to the next topic, that is key elements of contract of sale. So first one is two parties, and this comes under section 5 of this act. So first one is two parties. There must be a buyer and a seller. Both should be different persons. You cannot sell goods to yourself. But note, one co-owner can sell to another co-owner. The second one is goods. The subject matter must be goods. So as per this act, goods mean every kind of movable property, that is which can be moved. Property which can be moved only comes under the head goods here. So this also includes stock, shares, growing crops, grass and things attached to land which can be separated, as well as immovable property like land or buildings is not covered. The third one is transfer of ownership. So this is the main purpose. The seller must transfer or agree to transfer ownership to the buyer. The fourth one is price. The consideration must be money. This money is called price. Last one is mutual agreement. So there must be offer by one party and acceptance by the other. Both parties must agree on the same thing in the same sense. And this next topic is difference between contract of sale and agreement to sell. So the first basis of difference is transfer of property. In contract of sale, ownership of goods transfers immediately to the buyer. In agreement to sell, the ownership transfers in the future. The second basis is type of contract. So in case a contract of sale, it is an executed contract. So here executed means the contract is already completed. The main act of transferring ownership is done. Nothing remains except delivery or payment. An agreement to sell is executory contract. That is, executory means the contract is yet to be completed later. The main act of transferring ownership is still pending. It will happen in the future when conditions are satisfied. So if ownership passes now, it is a sale and executed. If ownership passes later, it is agreement to sell and executory. The next type of basis is type of goods. So in contract of sale, it applies only to existing and specific goods. That means existing goods means goods that are already in existence, which are owned by the seller. And specific goods means that are identified and agreed upon at the time of the contract. In case of agreement to sell, it applies to future or contingent goods. So future good means which will be manufactured or acquired by the seller later. And contingent goods means goods whose acquisition depends on some uncertain event. Now the next basis is risk of loss. In contract of sale, risk passes to the buyer immediately, even if goods are still with the seller, because ownership has already transferred. If goods are destroyed by fire or theft without seller's fault, the buyer suffers the loss. In case of agreement to sell, the risk remains with the seller. Since the ownership has not yet passed, seller bears the loss if goods are destroyed. Now let's move on to the next basis, that is breach of contract. So breach of contract means what remedy seller has if buyer fails to pay. So in case of contract of sale, if buyer fails to pay, seller can sue for price or damages. Because ownership has already passed, seller can demand the full price as goods are now legally buyer's property. Now, in case of agreement to sell, seller can only sue for damages and not for the price. So goods type, risk and remedies all depend on whether ownership has passed or not. Now let's move on to the next basis, that is rights against third parties. So this means who can the buyer claim against if there is a dispute. So in case of contract of sale, buyer gets rights against the whole world, including the seller. And in case of an agreement to sell, buyer gets rights only against the seller. Now the next basis is insolvency of buyer. So insolvency means the buyer is in a situation where he is unable to pay his debts. So in contract of sale, if buyer become insolvent before paying, the seller may claim dividend from the official receiver. And in an agreement to sell, seller can refuse to deliver goods until payment is made. So since ownership is still with the seller, he is protected. The next basis is insolvency of seller. So in case of contract of sale, if seller becomes insolvent after sale, buyer can claim goods from the official receiver. And in case of agreement to sell, buyer cannot claim goods. That is, he gets only a dividend as a creditor. If ownership has passed, buyer is stronger, and if not, seller is safer. Now let's move on to the next topic, that is example of a contract of sale. So let's understand with a simple example. So Mr. A agreed to sell his car to Mr. B. Now this was not an immediate sale. It was an agreement to sell because the contract has two conditions, a specific price and a specific date. And the most important point here is that if the payment was not made on that date, the sale would not occur. So what does this show? It shows that the ownership of the car remained with Mr. A till that date. Mr. B would become owner only when he pays the price on that agreed date. If he fails, the contract ends. This is a perfect example of agreement to sell becoming sale only after conditions are fulfilled. Now let's move on to the next topic, that is how a contract of sale is made. So under section 5 of Sale of Goods Act 1930 tells us how any contract of sale is created. So the first one is, it is created by two simple steps: offer to buy or sell goods by one party and acceptance of that offer by other party. The contract of sale may include immediate delivery of goods but payment may be later, immediate payment of price but delivery later, both delivery and payment immediately, and this is known as cash sale, payment or delivery in installments like EMI purchase, and postponed delivery or payment. This both can happen on a future date. So the contract starts with offer and acceptance, and the act allows all types of payment and delivery terms. Now let's move on to the next topic, that is forms of contract of sale. So the first one is writing, that is the whole contract is written down and signed. The second one is orally or word of mouth. Third one is partly written and partly oral. Fourth one is implied through conduct of parties. That is, there is no words at all. The behavior shows a contract. So all these forms are valid, but they are always subject to the law in force at that time. So if some special law says written contract is compulsory, then we must follow that. Now the next topic is types of goods. So there are two types of goods, specific goods and future goods. Specific goods are that which are identified and agreed upon at the time of contract. For example, you point to a specific red iPhone in the shop and say, I want this. That iPhone is specific goods. Sale of specific goods is usually a contract of sale. The next type of good is future goods. So these goods are one which will be manufactured or produced or acquired later by the seller. They do not exist at the time of contract. For example, let's say a tailor agrees to stitch a shirt for you. So this shirt does not exist yet. So this is an example for future goods. Now let's move on to the next topic, that is document of title to goods. So in many commercial transactions, physical delivery of goods is not possible immediately. So contract of sale may transfer documents of title instead of actual goods. So here transfer of that document means transfer of ownership. Now let's see some of the common examples of documents of title. First one is bill of lading, that is used in shipping. It is used by the ship owner when goods are loaded on a ship. It is a proof of receipt and a document of title. Next one is dock warrant, and this is issued by dock authorities. It certifies that goods are held in the dock. The third one is warehouse keeper certificates, and it is issued by a warehouse owner. It shows that specific goods are stored in his warehouse. Next one is wharfinger certificate, and this is issued by wharfinger who looks after goods at a wharf or port. The next one is railway receipt, and this is usually issued by railways when goods are booked for transport. So in business, instead of giving 1,000 bags of wheat, the seller may just give the warehouse certificate, and the buyer becomes owner by holding that certificate. Now the next topic is important elements in a contract sale. First one is price, second one is quality of goods. So this means there must be money consideration for goods, and quality of goods means the condition or state of the goods being sold must be good. Now let's move on to the next topic, that is essentials of a contract of sale. So as we have mentioned earlier, there must be two parties, buyer and seller, as well as there must be goods to transfer. The next topic is transfer of ownership. The main objective of a contract of sale is a transfer of ownership, also known as the title of goods. So this is the core of the whole act. Without transfer of ownership, a contract of sale cannot exist. The next topic is subject matter of the contract. So subject matter of the contract must be goods, and goods means movable property only. So as per this act, goods includes stock and shares, growing crops, grass, things attached to land which can be separated before sale. So it can be moved, it is goods. If it cannot be moved, it is not covered here. Now let's move on to the next topic, that is consideration. For any contract of sale to be valid, it must have consideration. So this is a very strict rule. If there is no money involved, it is not a sale. The next topic is agreement to sell versus sale, and this comes under section 4 subsection 3. So agreement to sell means the transfer of ownership will occur in the future, and sale means transfer of ownership happens immediately. Then the modes of contract we have already mentioned. The contract can be in writing, by word of mouth, partly written and partly oral, implied from conduct of parties. Now let's move on to the next topic, that is subject matter, and here we have mentioned earlier about existing goods, future goods and contingent goods. Let's move on to the next topic, that is sale of perished goods. So now an important rule about perished goods. If specific goods perish or are damaged before the contract is made and the seller is unaware of it at the time of contract, then the contract becomes void. So void means the contract has no legal effect. It is cancelled from the start. Now let's move on to the next topic, that is example of perished goods. So merchant Ragesh agreed to deliver 40 kgs of mangoes to Mahesh. So Ragesh agreed to deliver 40 kgs of mangoes to Mahesh. So delivery was planned within 2 months. So this was an agreement to sell because delivery was in the future. And due to bad climatic conditions, the mangoes ripened early or spoiled or could not be delivered because the specific goods meant for the contract were destroyed, and then the contract becomes void. So void means the contract just ends automatically. Ragesh cannot be forced to deliver and Mahesh is not bound to pay. Neither party is at fault here. So perishing of goods comes under section 7. So this applies when specific goods perish or are damaged. So for example, if specific goods perish before risk passes and no one is at fault, the contract becomes void. Now let's move on to the next topic, that is fixing the price, and this comes under section 9. So as we know, price is an essential element of contract of sale, but this act is very flexible, and this says that the prices in a contract of sale may be filled in three ways. That is directly stated in the contract, that is the contract amount is written. Second one is left to be fixed in a manner agreed in the contract. The parties don't write the price, but they decide a method to fix it later. The third one is determined by previous dealings between parties. If two parties do businesses, the price can be based on their past transactions. So for example, a shopkeeper always supplies paper to a school at rupees 500 per bundle. Next order is placed without mentioning price. The price will be 500 based on previous dealings. Now let's move on to the next topic, that is price determined by third parties under section 10. So parties may agree that a third person will decide the price. But what if the third person cannot fix the price? So if the third person fails to determine the price, the agreement becomes void. That means it just ends. No one is bound. The next topic is when third party is prevented. Now what if someone deliberately stops the third person? If the buyer or seller prevents third person from fixing the price, then that person is at fault. The other party can claim damages. The next one is stipulations in contract under section 11. So this talks about the terms of the contract. So a stipulation means a term or condition mentioned in a contract, and it may relate to time of payment, delivery or other contract terms like quality, packing, mode of transfer, etc. So this is all about the first subchapter from Sale of Goods Act 1930. Will be coming up with the following subchapters in the next videos. Until then, keep learning and keep growing. Thank you. Have a nice day.